Consideration in contract law. So, what is consideration? Now, as per the definition given under Section 2D of the Indian Contract Act, we say that when at the desire of the promisor, the person who makes the offer or proposal, the promisee is the person to whom the offer is made, or any other person has done, abstained from doing, or does, or abstains from doing, or promises to do, or to abstain from doing something, then such act or to abstain from doing something, such act or abstinence is called consideration. For a better understanding, let us understand these inferences one at a time. So, when at the desire of the promisor, the consideration must be given at the desire of the promisor, the one who is making the offer. Who is giving the consideration? The promisee himself or by any other person. So, one who is making the offer at his desire, when the person to whom the proposal is made is doing or abstaining from doing something, then it is called consideration. And what is the form of consideration? If we talk about the form of consideration, we can say that it may be an act, that is to do something, or to abstain, to refrain from doing something. Both can be considered as forms of consideration, that is to do, to perform an act, or not to do an act is also a consideration. When the consideration should be made? When it can be past, present and future also. This is a very common question that is asked, that can the consideration be past, can it be present, or can it be a future consideration? So, if we go by the definition, we clearly see that consideration may be a past act or abstinence, something that I have abstained from doing. Then I may do or I may abstain from performing an act in future, or at the moment I may do an act or I may abstain from doing it. So, if we go by the definition, yes, consideration can be past, present or future as well. Privity to consideration. The term privity to consideration means that the consideration must be given by the party to the contract. The effect of privity to consideration is that if the consideration is given by a person who is not the party to the contract, then the agreement would be considered as though it is without consideration. Therefore, the doctrine of privity to consideration, as we see, is applicable in the English law but not under the Indian law. Why? Because as it is established by Section 2D, that the consideration under the Indian Contract Act may be given by the promisor or by any other person, and such agreement is valid and enforceable by law. Thus, privity of consideration is not applicable in India.